Okay, we are live. Give it 1 minute here. Okay, it's just a little after 4 o'clock. We can get started with the stream, and we are live on YouTube. My name's David Bilodeau. Thanks for joining us today. I'm a family law attorney practicing in Newton, Massachusetts, and I have the honor of being joined by Judge Gregory Roach, who is now retired, and his private practice consists of mediation, conciliation, private arbitration. He's working out of Concord, Massachusetts, but I'll leave information in the caption of how to reach him afterwards, after the stream. Also joined by practicing family law attorney Sandy Derlin, who works at Schmidt and Federico. And I also am joined today by Dr. Peter Cohen, who is a vocational expert. And I've personally worked with him. And Peter, how many cases have you testified on in your career? Lots.
About 175.
Oh, okay. Wow. That's pretty good. Sandy, have you done 175 trials?
Yeah.
Oh, okay. All right. Good.
I've been doing it a long time.
Well, thank you, gentlemen, for joining me today. The topic today is COVID-19 impact, specifically as to loss of job. And it's a topic that, as a practitioner, has come up actually quite a bit for me. I've seen the two big ones on my end and I'm interested in what Sandy's seen too. Is folks who have either someone's lost the job and they want to talk about a support recalculation, or someone has had a reduction of income, still at the same job, and ultimately wants to have the same discussion. Where do we go from here? Are you seeing those types of cases come up too, Sandy?
I would say so. And I think a lot of people are probably still circling and waiting to do something and haven't made quite a decision yet. And there may be a lot more down the road once things sort of settle out in the courts.
Well, that's what I'm wondering too, especially since it's so hard to get in right now. But it's a very tough issue for people. One of the big questions I had was, in the case where I think a lot of people wonder, about the legitimacy of the job loss, or the convenience of the timing of the job loss. You always run into those sorts of conflicts in these cases. And one of the reasons I wanted to bring Dr. Cohen in was to talk about his perspective from the vocational side, which is, the first question for you, Peter. Are you seeing a big difference? I know, the big headlines that we all see in the Globe and on TV, unprecedented unemployment rates right now. But are you seeing a big impact in the divorce and paternity sort of realm?
I think it's about on average, but then again, as I always said to you gentlemen and everybody, you have to look at the data, and this comes back to Mr. Bloomberg and God we trust. Otherwise, look at the data. And that's what I do. Interestingly, most of the people that I'm working with have a bachelor's degree plus. Currently, well, let me go back to last month, if I may. Last month, the unemployment overall was for the nation about 6%, but the unemployment rate with people with a bachelor's degree plus was 2.0%. Currently, I'm looking at data that for the past month in April, the unemployment rate for individuals with less than a high school diploma is 21%. High school graduates, 17%, some college, 15%, but a bachelor's degree in April was 8.4. In March, it was 2.2. In the number of years that I have done this, I've always found, give or take a little bit, the unemployment rate, obviously, the more education you have, the higher the probability is you're going to find a job. I can talk more about that later. But that's
Can I ask you a question, Peter?
anything you want.
Is that broken down by regions? Or by just across the board, the United States?
It's like everything that I presented to the court. I can do it United States, I can do it by state, and I can do it by geographical area. So it would be the same analogy if the question was asked, how much does an X earn nationwide? I can tell you. I can provide that data statewide, and seeing we're in Massachusetts for any major cities in the Boston area, in the Massachusetts area.
I guess that was my question, since we're in Massachusetts. What are the Massachusetts rates?
I haven't done that yet.
Boston.
Some of it isn't up. The April data for people with a bachelor's degree in the Boston area still hasn't shown up on the reports.
8% unprecedented for bachelor level employees.
Nationwide, Sandy, yes.
Yeah, what was it? What was it 6 months ago?
2.2%.
Oh, so it's about 5.5%. You're saying 5.8?
Yeah, something like that. But it's typically half the rate. Now, the other interesting thing, the question hasn't come up. We discussed this yesterday, that I'm currently on a matter where the individual is a marketing manager. I went online to look at current job openings. There were over 1,000 that were posted in the past 30 days.
Wow.
And I'm not going to sit here and tell you, as I usually do, not everybody can get the job, but if you take 1,000 and you throw out the probability that they won't fit in at 90%, there are still 100 jobs there.
Well, I mean, that's one of the questions I had was, if someone comes along and says, listen, I lost my job because of COVID-19, I can't get a new job because of COVID-19. It sounds like you're saying that doesn't really tread water.
It's all contingent upon the education. Because service occupations, as I pointed out before, nationwide, the unemployment rate is 27%. But the unemployment rate nationwide, again, Judge, for management and business people is 6.2%. 6.2% traditionally has been a nationwide average unemployment rate.
Oh.
Wow.
So where do we go from there? It sounds like you're not buying into it.
I can't say. My role is I present the data to the court. Thank goodness I'm not the one who has to make the decision.
Yeah, but if I'm right, your analysis is pretty much the same as it was pre-COVID-19. Are there any so let me ask you this, is there any new factors that you're now considering when you assess someone's employability?
I'm looking again, going back to the Shula v. Shula. And that simply would be education, training, and experience. What I also look for that is off right now is the occupational projection. How many jobs are going to be needed over the next 10 years or over the next year? And the third part being, you go online and see how many jobs are being posted. That has not decreased at the higher end, in my opinion, significantly.
Yeah.
Let me just weigh in on what my perspective, because I do a lot of appellate work, and sometimes I'm troubled by what I see coming out of the trial court and the decisions made by Judge Roach's colleagues. And the discretion given to judges is so broad, and the Reform Act and the guidelines both talk about unemployed and underemployed individuals being eligible, if you will, for attribution. I think it seems like there's like 4 parts to this concept. There's unemployment, underemployment, available jobs, and reasonable efforts to find a job. And you sort of follow those along, and data seems to me falls into this concept of available jobs. And if there's 1,000 jobs and a 90% sort of attrition rate, and that leaves 100 jobs, that's certainly a lot of jobs that are available. But I think that has to be sort of paired with the efforts to find a job, because the cases, I think, at least the published cases, suggest that the efforts really, I think, are maybe the most important component of this, because the availability of jobs, I don't think is sufficient to attribute income. I think it has to be found that someone is not finding a job for whatever reason. That's my view. And I think as time has gone on, the importance of an expert, I think, has been highlighted. And a perfect example is the case you were involved with, Peter, in the Macri case. Twice that case went up and came back.
And it's going again.
Well, okay, 3 times the charm. And the first time there was no expert, and the judge was found to be at fault in part for that, not for not being an expert, but for making findings that couldn't be supported. The second time through, your testimony certainly was a critical component of the decision. That's the appellate decision, to uphold the decision. I think it was Judge Gorman, if I'm not mistaken. And
It was.
It almost, I remember years ago when the Reform Act was enacted, somebody I used to work for many, many years ago, Bill Levine, said it was the Divorce Lawyers Full Employment Act. And it seems to me that the case law has developed where a vocational expert is more and more important. I don't know if you feel that way, Peter, but it seems to me that the decisions seem to really credit those cases where an expert is there, even if they're 2 experts, but nevertheless an expert. And in, I think, the Macri case, you were the only expert, if I'm not mistaken. And I think that weighed heavily on the trial judge. So I think, when you're looking at the broad ability of a trial judge to attribute income under, myriad of cases, Casey, I think, is maybe the leading case where they talk about it being a case-by-case flexible analysis with broad discretion given to the trial judge. I think you have to, as an attorney, you have to come in and say, okay, here's the data. This is why he lost his job or she lost her job. Here are the jobs that may be available, and here are the efforts. And I think without those 3 there, I think, in my view of the cases, absent that, you're not going to really have the same meat on the decision to attribute income to someone.
For the judge to respond to that.
Right. Well, I think, first of all, I agree with you, Sandy, that the experts' opinions or testimony is important. But as Dr. Cohen is aware, his testimony is it's expert opinion, but it's testimony that the court or the judge has to take into consideration with all the other factors. And I think a mistake sometimes that lawyers might make is that the phrase that the court can attribute income or a judge can attribute income for someone that is underemployed or unemployed is a simple phrase, but it's a question of proof. And clearly a judge has to examine all the facts, not only the testimony from Dr. Cohen as to the data, but also has to consider other evidence and particularly what efforts the person has made to obtain employment. And I'll give you a quick example. I had a case with Dr. Cohen many years ago when I was on the bench. And he testified very credibly that there were, based on the husband or the ex-husband's training, education, and experience, and based on the number of jobs in the area, that there were X amount of jobs available, and they paid between, and I remember the case, $75,000 and $125,000. But the evidence presented by the lawyer for the husband indicated that he had applied to 75 different openings, had been spends 4 or 5 hours a day on the internet reviewing monster.com, has had interviews, hired a headhunter. So even though I found that Dr. Cohen's testimony was credible, which it was, it's the data, I did not attribute income because clearly the evidence showed that the husband had made reasonable efforts, very reasonable efforts to become employed, and he couldn't be and couldn't get a job. So, and I think that the Casey case, I agree with you, Sandy, but also the Emery and Stuyvesant case, 91 Mass Appeals Court 502, I think, for practicing lawyers should read that case because that summarizes the law very succinctly.
Yeah.
And I just want to quote one phrase. I don't want to get into lecturing, but I think it's just a key phrase in that case where they said, neither this court, and it was the appeals court, nor the SJC has affirmed an attribution of income made without a finding concerning the party's reasonable efforts to secure employment. And if lawyers come into court in front of a judge, they must present the subsidiary evidence so the court can make subsidiary findings that support the ultimate finding.
Mm-hmm.
And in that case, they sent it back because they said the judge had no subsidiary findings to make the ultimate finding that the husband in that case had the potential and the ability and to earn income and therefore attributed income. So I think that if somebody's coming in representing a spouse that is unemployed or underemployed, they need to present a cogent case to the judge of all the reasonable efforts that that person has made in order to obtain employment, and don't come into court before that person has made those efforts.
Mm-hmm.
I just wanted to reiterate what Sandy had indicated, and that's the law. As I said, I sat on many of those cases, and you have to judge the case on the totality of the evidence, the credible evidence that comes forth. And it's very important, if you want a judge to make a finding, you have to present evidence to establish that finding. You just can't just assume because someone had a $450,000 a year job, let's say, and now is making 150, that a judge can just attribute that higher income to the person.
Right.
It's
In response to that, a reasonable effort, that Zelensky v. Zelensky, reasonable effort. I was fortunate enough to be the expert on that. Also looking at transferability of skills. I currently, as I look in my office, I have a box where the client, not mine, the other side, has looked for a job. He has 4,000 pages that was submitted to me. And 90% of those, he doesn't remember this, that, or anything else. And they were all sent to a blind box. The best thing, and it's been published now, there are 70,000 copies published. What Color Is Your Parachute by Bowles. And according to him, the worst way to find a job is to send your resume to a blind box. I can ad infinitum of job search, because I used to do that at one time. That is not my role in the court, but I certainly take into consideration, as I did with Macri, if you go through that, he didn't remember seeing any professionals, this, that, or anything else. They're looking for a job now for 6 years. Still hasn't found one.
Well, that was one of the things I was going to ask you, Peter. I mean, I think one of the tricky things that, we're seeing now with the COVID-19 issue specifically with that is there's a big time crunch now. People come, I'm curious, Peter, what do you have any sense of, I don't even know the right way to qualify this question, but over what amount of time do you usually evaluate someone's job search efforts? I'm assuming it's more than a couple weeks.
Couple months.
Yeah.
You've got to network. One of the big things, again, coming back to Bowles, there are networks people can meet with. You can go to the state and you share information. The best way, and I've used this for years, telling people, take your resume, do it 2 pages, do a good one. If you're looking for marketing, you go online and you determine who the vice president, whoever it is of marketing it is. The cover letter in, and you send that to that person, certified mail. That has been that's my idea that we used to do 30 years ago when I was in Washington, D.C. Because people they will open certified mail and they're saying, this person is really trying to get a job. But it's the networking and not sending blind things and saying, I spent 6 hours on the internet. That's not the way to find a job, regardless of your education or what you're getting paid for it. It just isn't. But that's not my role in the court.
No, that's the role of the judge to determine whether or not there's been a credible, reasonable effort made. And ultimately, it's the job of the attorneys to present that evidence to the judge.
In every report that I put that in, providing she makes a reasonable, in-depth effort to find the job.
I know in the Emory case, the length of the job search was a critical component, one of the decisions.
Yeah, right.
I'm just curious, Peter, in relation to other down economic times, maybe the recession of 2008, is there a reasonable expectation that, and I know it's all, conjecture, but, can you sort of assume that the economy will sort of have a gradual, upturn, it sort of follows a pattern, so that if someone isn't sort of working within the expectations, they're not making a reasonable effort, if that makes sense? You said there's a period of time that someone should sort of certainly set aside to make a reasonable effort for a job. But at some point, when do those reasonable efforts, and they don't bear fruit, at some point, it's no longer their fault.
But what have they done to determine the definition of a reasonable effort? And that's why I'm talking about what is your parachute, or going to somebody, job clubs and things, that people know that. They know what to do. They know how to guide you. That's, to me, a reasonable effort, where you have gone and you have letters that you've sent, not to blind boxes, people you've talked to that can be authenticated. What was their position? Have you knocked on doors? I can go on and on.
Well, not knocking on any doors right now these days.
Can I follow up with that, Peter? Isn't it the trend now that most companies want you to respond electronically, as opposed to setting up interviews or calling? They wanted the information or your resume electronically?
They do, but that's going into HR, and that's why I use the thing, trying to get right to the person, of being face-to-face if possible, and doing things like that. Again, I'm looking at the data according to Bowles' Color Your Parachute. Sending letters to a box is only 4% successful.
Yeah. Well, correct me if I'm wrong, Peter, but there's a difference between sending, applying to 1,000 jobs on, Monster or Indeed or whatever, and using doing Zoom networking, emailing your, contacts at specific people at companies, doing those, doing a an online network. There must, online networking group and things like that. That's totally different, right?
Yes, absolutely.
And is that more, I'm assuming that would be, more extensive effort, than just doing the 1,000, hit go on Indeed or whatever it is.
And that's what I have sitting in a box this big in front of me right now that I went through, of 4,000 pages. Now, interestingly, it's 4,000 pages, but on each page is I sent to. That's all it says. So, I mean, you've got to look at the credibility of what specifically they're doing, and that's why it's left up to the judge.
Yeah.
I'd like to see something, the definition of reasonable effort, somewhere in the law, the definition.
Oh, I think that it's common sense, and I think that's another value of your expertise and testimony would be examining whether someone has made a reasonable effort to obtain to obtain employment. Just what you said would be important for me if I was deciding the case. That is important evidence how the person went about trying to obtain employment.
And that's something.
I don't think you can define reasonableness. I think it's a variety of factors.
It's a variety of factors, but you go back and some people might look whatever it is for a month and then they give up. Are they doing this or doing that? I want to see, in fact, when an attorney asked me that they're going to take and depose somebody, can you write some questions for me? And what I put into that to give to the attorney, what efforts have you made? And I want it open-ended. I don't want to say, ask the client, have they done A, B, C, D? Yes, yes, yes. What foundation do they have for it? Can you share with me what you have done to find a job? And keep probing what they have done. To me, that's very important to look at when I'm going to go into court first. I do not put that into the report, but I will testify to it.
Right.
From that position.
Yeah,
I think that from my perspective, I think it's almost perilous to not really come into an attribution case with overkill, because I think the judges have such discretion. And I think judges, and I know this from personal experience, judges act differently. Different judges on very similar facts act differently. And I know that's part of the game. And I know that's what we deal with the individual calendar and whatnot, and the idiosyncrasies of a good judge or a bad judge, or one or male or female, what have you. We have to deal with it. But to go into court without really going almost overkill on this process, if you're either defending an attribution claim or you're asserting an attribution claim, you really have to almost overdo it so that you have that evidentiary foundation. Because the cases suggest a couple of different things. The definition of reasonableness, I think, is addressed somewhat in a case called Ulan versus Polanski. And I think there, my memories might be a little faulty. I think there, the individual took a lesser paying job. It was still a good job. It was a six-figure job. And I think the decision was, we're not going to make someone look for a job indefinitely to get that higher income. It's reasonable at some point for that person to take a lower paying job. But it all got into this notion about the efforts made and the length of the efforts made. And as you said, Peter, the jobs that were being applied to and unsuccessfully, assuming a good faith effort. So, you really have to throw it all at the judge. Otherwise, I think it's like, oh, well, something's going to happen and it's not going to go my way. And there's not going to be much you're going to be able to do about it.
Sandy, I got into this. I never looked to do this. Remember a guy, Monroe Inca?
Oh, yeah.
Monroe called me and asked me to do this. And I had already retired. And I said, gee, I think it'll be fun to start a whole new career at my age then, but it's been fun and I've learned. And the big thing that Monroe said to me, your most difficult task, Peter, in all due respects to the judge, is teaching the judges what you know, sharing with them what's in your head about this. And it's been fascinating and very helpful, I think.
And I do think you have to play to your judge too. I mean, I don't want to get into that in this conversation here, but you know, some judges are far more loose, if you will, than others. Others demand more and some don't demand as much. And if you have that advanced knowledge, you know, you sometimes can get away with what happened in the, I think with Judge Langlois in the Casey case, where he said, don't just show up and say he doesn't have a job and attribute income to him. That's not going to cut it, is I think the words he used in the decision. And I think some people do that.
And he did the same thing in Kelly v. Kelly.
Oh, maybe it was the Kelly case. I could be wrong on that.
It was the Kelly case where he said, and Mrs. Kelly, I too would like to be playing golf all day.
Right. Well, yeah, but that, I think Mrs. Kelly was the artist, wasn't she?
Yes, she was.
And I think he was taken to task for that, I think.
Yes,
because
he
they
was.
found that, you know, there's avocation and there's vocation. And they said at some point, an artist is an artist. And that's what an artist does, even though they don't make a lot of money. And I'm paraphrasing.
And that's what I would talk about. And when I work with younger people way back when, I talk about where do you see yourself when you're 35 or 40 that have, how much money do you want to make? Or is it the job, the avocation versus vocation? That's a big part of it. And it's just fascinating with the whole thing. He is now retired, a judge, where the attorney who retained me said, the judge is only going to give you 10 minutes on the stand. So let's get this thing over with. This is not about me, it's about the judges and it's about the court. I got off the stand an hour and a half later. And as I'm walking out of the court, the judge said, Dr. Cohen. I said, yes, Your Honor. He said, that is the best interpretation I've ever heard. He said, you have changed my mind. I felt so proud, not because of me, that I brought this forth. And this was about 15 years ago.
Sandy, I wanted to ask you, what sort of things are you seeing or doing? You know, it's all well and good to have the expert lined up and get them ready for trial. But I mean, we all know you could, you know, by the time you submit your complaint and get your summons and then when you put Dr. Cohen on the stand, I mean, that could be a year, 2 years later. What are the things people should be looking at, you know, doing in the first 2 or 3 months when an issue like this rises?
You know, Peter said something very interesting, and that is, you know, the emails to a blind box or the cold call, if you will, sort of communications. I remember a case where a guy had done something similar, sent out thousands and thousands and thousands of emails, and he was taken to task by the judge for that reason in so many words that, you know, these are just essentially almost like form letters, or it's almost like spam. You're just sending out, I don't know how he was doing it, whether he was doing it through Indeed or Monster or what have you, I don't know. But I think at some point, you know, when you walk in the door, you sort of have to really set somebody up and start this process where, you know, as has been suggested today, where you really sort of start to prepare a template or a binder, which really breaks down all these efforts in very detailed and nuanced fashion so that you can sort of, you know, blow the judge away otherwise. Because I think so much of the job searching process tends to be somewhat formulaic. I mean, you go on to Indeed, you post your email, your resume, and maybe you get a hit, or maybe you don't. And and you go on Monster, and what have you, and I don't think that's going to cut it. It doesn't seem to be enough, which suggests going to a headhunter, spending the money to go to a headhunter, or to take a different approach where you're not just sending the emails, you are sending letters, personalized letters the old-fashioned way with a copy, whether you're PDFing or what have you. a different approach, because I just think it's dangerous, frankly, to give it to the judge, because I just think it's a real crapshoot when it comes to what you may get. You know what they say, don't watch sausages and laws getting made. I think the same thing can be said sometimes for judgments. If you're not careful, you're going to get something that looks like sausage.
On several occasions, I've been asked to be retained by the person who was going in, that was going to show they've been looking for a job. And I said, before I'll do that, I want to sit down with the person and see what they have done. Because if, in my opinion, they didn't do what I think they should be doing, I am not taking the stand to defend them.
Yeah.
I think that's very important. And I think it's important for the attorney to say to your client, make a concerted job effort, because the courts are going to look at that.
Yeah.
And I think that from lawyer's point of view, if you're coming into court with an individual that has lost a job, that I agree with Sandy, it's not the quantity of applications that someone's made, it's the quality, what they've actually done. And I think it's, from my perspective, at least when I was sitting on the bench, you could get a pretty good idea by the end of the trial if somebody was just mailing it in or actually invested in obtaining employment. And secondly, if you're defending someone where the other spouse is seeking to attribute income, you have to, again, present substantial evidence that they made reasonable efforts and they just weren't able to find a job.
What sort of, Judge Roach, what sort of information would you be looking at in a motion for temporary orders or something earlier on in the case?
Well,
When they don't bring the expert to the hearing with them.
right. Well, in that case, it depends whether it's alimony or child support. I think that's a difference. First of all, if it's child support and somebody was recently terminated or became unemployed, then there's a question whether or not they have a severance, whether or not there's unemployment, whether or not they're assets that could be used for child support or can be taken into consideration. Alimony is a different situation, as I think it was the Williams versus Massa case, but I could be wrong, where they said that a loss of employment or loss of income does not necessitate a reduction, a temporary. It's only permanent. So it's always difficult on temporary orders. A lot of times on a temporary order, if the person was unemployed, I would keep the order in place, but enter a reduced amount temporarily, so that when they came back in 2 or 3 months, if they had become employed, then you could deal with the arrearage.
Yeah.
Not on a contempt basis, but you would be able to, as a judge, either sort of waive the amount that the arrearage or have it paid over a period of time.
Yeah.
But it's awful, it's difficult, because if somebody's just recently unemployed, couple of weeks, 3 weeks, you might, I don't think that many judges would give you that temporary relief. But if it's several months, and depending on the presentation at the motion session, what efforts they made, you're more likely to get some relief.
I mean, unfortunately, I'm interested in if Sandy's had this experience. Unfortunately, I've got a number of these cases, but nothing's gotten in front of a judge yet, you know, during this COVID phase we're in with the courthouse closed to the public. But we just lost Sandy.
Right.
You know, pre-COVID, I had a case and, you know, I represented the recipient, and it was very similar to what you just said, Judge. What I pointed out to the judge I was in front of at that hearing was that even though the cash flow had dried up because of a job loss, there was significant money in the bank. And I thought, I mean, at the time, I thought I was making a reasonable argument that it was premature.
Right.
And that the gentleman should have had to keep paying for at least some reasonable period until he could I felt like I mean, I argued that the burden was on him to show that he couldn't get a job within a, you know, a reasonable period of time. But it's always a tough argument, I feel like.
Well, at a motion session, it's a difficult argument.
Yeah.
It was a child support or alimony.
This one was alimony.
Yeah, and that's a little different than the child support issue.
Yep. We actually got a good question here. The question is whether so this is on a modification, whether a prior attribution of income in a judgment or a separation agreement would affect someone's ability to come back on a mod due to a job loss. What do you think about that, Judge?
No, my initial reaction would be no, because it might be a change of circumstances, and it depends what the circumstances are when they're in front of the court. The court certainly can take notice of what happened previously, but you know, those questions are hard to answer in an abstract.
Yeah.
As you know, all these cases are different. The different facts, the different situations. So they're hard to answer in the abstract, but
Yeah.
So my answer to that question would be not necessarily, but it depends on what the present situation is and what the facts are.
Well, it's tricky because if there's an attribution that was part of it, you know, part of a judgment, how do you show what the material change from that attributed amount would be?
Well, that's true. But if there was a support order based on an attribution, and then the person was paying that, then came back in and said, I've lost my job again, to that effect. Yeah. Again, without being vague, it's tough to answer that question.
Yeah. Well, I think the other thing that's come up for me, and I'm curious, Judge, you know, again, these cases are very, very hard to get done in the courthouse right now.
Right.
And I've tried very hard to steer people into mediation or even arbitration. I know I've talked to some sitting judges who maybe in the past weren't inclined to send people to arbitration for child support. But I don't know are you getting feedback from folks you're talking to that more of the sitting judges are open to that right now?
Yes, I've heard that. Yes.
So are you seeing an uptick in your arbitration cases? People trying to deal with this out of court?
I haven't seen it yet, but I've had a lot of inquiries. But
okay, good.
The problem is that most people don't want to do it by Zoom.
Oh, okay.
You know, doing it by Zoom creates a lot of problems because if you have both parties and have children involved, are they in the house? You know.
Oh, yep, that's a good point.
Yeah. So most of the lawyers that I've dealt with really are trying to hold out for, excuse me, in person.
Yep. I mean, I think one of the considerations, you know, I actually.
Arbitration, by the way, I didn't mean to interrupt, but arbitration would be easier to do by Zoom than mediation or conciliation. I consider it conciliation, but.
Oh yeah, that makes sense. One of the things that I think lawyers and parties have to get a lot more creative with how they can do, you know, I recently had a situation like this and we ended up reaching a stipulation. And what we did was we just added a bunch of checkpoints. for this period of time, there's going to be no payments period. And then after these 3 months, we're going to do a review. And if the review goes, if the job's still not there, then it changes to this other thing. And, because I think part of the problem is on a modification, this is going to be, I think, a real issue next year. Is you're going to see people come in on their mods because they lost their job. So their initial mod was, well, I lost my job, I shouldn't have to pay support anymore. And then at some point they find the job and then they say, well, wait a second, take my annual salary from 2020 and recalculate my support for 2021.
Yeah.
So I think it's going to be a real mess for people to manage.
The other thing I think is important, if somebody has lost their job or has been, their income has been reduced, from a judge's point of view, if they see that person has continued to make some effort of payments, whether a reduced amount or whatever, I think that most judges would look favorably upon that.
I apologize. I got kicked off with some internet problems, and I don't want to repeat something that may have been said while I was gone. But one other thing that what Judge Roach just said made me think of it, and that is when you're coming into court after a job loss and putting aside the discussion we've had about the reasonable efforts and the available jobs and whatnot, is that you sort of act more, with more contrition in terms of your spending habits and your assets, and you don't. I think you sort of have to, adjust your expectations and your lifestyle somewhat. The judges can look, and the cases talk about it, the judges can look to whether you have assets that you can meet your obligation, which is all well and good. But if you don't change your lifestyle and you continue to spend, I think that's not going to endear you to a judge. And it also suggests that, there could be other motives. It at least raises the question about whether you have a motive for the job loss, or whether, you have expectations that you're going to find a job and you're just playing it sort of fast and loose. And the cases talk about, reasonable prospects being used against you. So I think, lifestyle does factor in, and, certainly using your assets to make a good faith effort to meet your obligations, as Judge Roach says, is important. But I think you shouldn't then go buy yourself a Ferrari, even though you may have been planning to, or, you had every reason to expect you could. I think that would also factor in.
Sure, and that raises the red flag to a judge. If your lifestyle hasn't changed and you're still expending the same amount of money, but you can't pay the support, you're not going to be very successful in getting a judge to reduce your support on a temporary basis. Anyway.
Yeah.
Judge, could I ask you one question, David? Excuse me if I interrupted you. There are some cases which talk about, and it's the case specifically is the JS versus CC case,
Right?
Where someone was found to be sort of excessive with excessive cash held in an S corp.
Right. Yep.
From your perspective, what does a judge need before he or she can make that determination that someone is not, is either, it's one thing to run personal expenses to a business. That's sort of a classic way of hiding income or attributing income, as the case may be. But what about, if someone, has excessive earnings? How does a judge make that determination? And how is a judge qualified, or how do you qualify a judge to make that decision?
Well, first of all, you have to present the evidence. And I think that case spells it out very clearly, particularly with retained earnings. What has been the history of the retained earnings? Are the retained earnings kept there for legitimate business purposes? All those factors go into it. It's not one, but one particular factor, but there are other factors they talked about. All of a sudden, the retained earnings gone doubled since the divorce has been filed. What's the business purpose for them? and I'll give you an example. It was an arbitration that I had, but I found that a portion of the retained earnings were excessive and used it for support.
Mhm.
And it was based on the co-owner's own testimony about what they, I asked him, it was brought forth, what are the retained earnings for? And he went through the expenses, and they had the retained earnings of 3 times what they normally were. And
Mhm.
so those are the factors. But I think that case spells it out very clearly. And you have to educate the judge, because most judges are not business people. They don't have accounting degrees. Most of them haven't gone to business school or took business courses. So again, I don't want to be redundant, but you come into court, you need to give the judge the evidence where they can make those findings, the subsidiary findings, which support the ultimate findings. And that's bringing in experts like Dr. Cohen on the vocational part of it, or business experts.
Well, I think this is particularly relevant right now because of these PPP loans that folks are getting.
Right.
You see a lot of, companies are coming into, several $1,000s of a loan, but there's this whole forgiveness side of it. So, if someone gets $100,000 falls into their corporate account and they use money, keep the staff going, and then they end up getting, this is something that's probably going to come up in the next month or two. I don't know if you're talking about this stuff with clients or not, Sandy, but I have clients asking me, well, what happens when I get $100,000 forgiven and it's just sitting in my bank account? How's that going to be viewed? I don't have a good answer for that.
Well, it would seem to me to be additional income, to be perfectly honest with you. I don't know how the IRS is going to treat it. I have no idea, but to forgive $100,000 worth of expenses, on the corporate ledger, either is additional income or you have to wipe away those expenses.
Yeah.
Adjust it accordingly. But
Right. Well, I think the IRS would probably treat it as income, right?
yeah, I would think so too.
Right.
I have
But
to double check.
if it's sitting in the account and it's been forgiven, then for support purposes, it can be used as income.
Well, I think Sandy's right. If it's, you get this, I guess you could say it the same, you get to the same result saying it's slightly different, which is you shave off the expenses.
Right.
And if the 100,000 comes in and it covers 100,000 of legitimate expenses, then that 100K of expenses is just off the books for purposes of the analysis. I think that's probably the cleanest way to look at it, I guess.
Well, there's so much unknown about that, and it's evolving. There'll be more legislation maybe, and more loans or money.
Second or third round.
Yeah.
It's just, it's a whole different area.
What are some of the,
And how the court is going to, or judge is going to treat it, nobody knows, because the whole thing is in flux.
yeah. Judge Roach, in some of the cases you're doing now, what are some of the ways people are reaching settlements and managing some of these complicated issues we've been talking about today?
Well, I haven't, since the virus started, since the end of March or beginning of April, I haven't had a arbitration.
Okay.
I have one next week, and I have 3 or 4 scheduled for the end of the month, but they keep getting put off. So
Yeah.
and strictly based on the medical part of it.
Yep.
Getting people together.
Sandy, have you run into any contempt cases on job loss issues, people not paying?
Not yet. I've run into some visitation contempt issues, but
Yeah.
not numbers yet anyway.
Yeah, I've had a couple, but nothing's happened on. I actually haven't received any summon. I have, I think 3 outstanding that I've been waiting almost a month for the summons.
Yeah. I mean, I'm waiting for some summons on some complaints. You know, God knows when they're going to
Yeah,
come in the mail.
yeah.
Peter, what does the data tell you, or what's your gut tell you? In 6 months from now, do you think that 8% unemployment rate for bachelor level employees will be halved, quartered?
I definitely think so. The jobs are out there for that cohort, that group. But then once the restaurants start to open and you're looking at service occupations, that 27% unemployment is going to start to drop down.
Hmm.
Go back, if you know your history, you can predict the future. So you can go back to 2000, what was it, in 8 or something? Everything was terrible and that came back. This too shall come back, but not right away. It's a different sort of situation. But getting people back to work, that's the game you're playing on it. It's like under Roosevelt with the WPA, Works Progress Administration, you were putting money into the people's hands. So it's interesting to me, I constantly see, because I'm looking at the computer, for Amazon. They have jobs all over for $20 an hour. That's $41,000 a year. I mean, if I were in the restaurant business as a waiter and I saw something for $41,000, I'd go take it.
Yeah. Well, you know, one of the other things that I talked to you about yesterday, Peter, is the CARES Act is sort of, in a way, sort of blocking what's, you know, progress on this front, I think, because there's lots of folks who are actually earning more money under the CARES Act than they are just working. So I'm assuming if someone stayed at home because they were getting this CARES relief for, was it 26 weeks, I think? I'm assuming that that would not bode well on them in terms of arguing that that is a reasonable unemployment.
Well, it's interesting because when I worked for the U.S. Department of Labor and labor funds the states for the unemployment, but it's up to the states of how they want to go about doing that. And you didn't usually, off the top of my head, if people were getting unemployment, you usually find a job until, you know, the last couple of weeks are up. They go out looking for a job, different types of periods. But I think the economy will turn around as it always has. We'll get by with this too. It's just patience. We have an educated workforce. There are jobs out there. There will be jobs out there.
Let me just say this, that you had mentioned 2008, and you did mention also, Peter, that there's a substantial difference between 2008 financial crisis and the present situation, because this is based on health.
Yes.
Have a situation where someone, there might be a job available, but they're fearful of taking that job because of the atmosphere at the office or at the plant or wherever it would be of the virus. And there's another issue lurking too. If in fact there's a second wave of this virus in the fall, seems to me until they have the vaccine or they have some type of medical or pharmaceuticals to deal with this situation, it's not going to be resolved before then.
Well, that's a great point. Saying is it reasonable to say, I didn't apply for the jobs because I'm afraid to go back to work?
Right.
And another point, which wasn't true in 2008 and so forth, is the schools are closed and the daycares are closed, and so many people. I mean, I have associates in my office who are going crazy because they've got 2 or 3 kids at home. And David, maybe you're running into this. You know, they can't. Summer camps are canceled, and the schools are canceled, and they can't come into. They're trying to juggle, and so I think that's a consideration which I'm sure a judge would have to consider, which wasn't the case in 2008. That's for sure. Right. So, I mean, there are some sort of unique aspects to what we're going through, even though they may be temporal, right. But I think they can't be ignored.
And also, if you have a highly educated person and that person has underlying medical conditions and is fearful of going into the office, and even though the job's available, what's the judge going to say?
It's a lot of evidence you got to bring into court.
Yeah.
I think we should change the name of the judge to Solomon.
Yeah.
Well, thank you very much, gentlemen. Our time's up for today, but I really appreciate your thoughts, and I'm very happy that you were able to join us today. And this will be posted live on YouTube, or sorry, recorded on YouTube. So if you want to go back and watch it again, you can, and I'll post links. We'll be doing another stream next week, the same time, Wednesday at 4 p.m. And it's actually, because this is such a big topic, we'll be doing further discussion about job loss, focused more on recalculation, specifics, alimony versus child support, and some of the issues that come up with contempt. So I think it's going to be another good seminar. So thank you very much to the panel, and take care.
You too.
Thank you.
David.